3 of our podcast, The Public Consequences of Private Justice.
Part of your civic duty, we don't, we've asked people to go to war. That doesn't happen all that often, thankfully, right? We don't make them vote. We really just ask them to pay taxes and show up for jury duty. And it's one way to try to force people more into their own democracy to sort of see the power that they have. So I'm wondering if the two of you can kind of talk about that, what your own experience has been in jury trials, and talking to jurors about their attitude towards it once they get to the end.
So every jury I've ever had, people grouse about getting called for jury duty, and there's a lot about it that is not particularly edifying, right? A lot of downtime waiting to get picked, to go through jury selection. The pay is not at all commensurate with the solemnity of the duty that they assume. But I've not ever had jurors say after the fact, this was a waste of my time. Every juror that I've talked to after a jury trial has felt like they were empowered, that their voice mattered, and their voice, of course, does matter in a jury trial because they are the deciders of the facts. And so, I think it's very interesting, and it's often overlooked. We talk about Batson challenges to juries, the striking of jurors for racial reasons. Mm-hmm. One of the reasons the Batson case was decided the way it was is because it was not just discriminatory to criminal defendants, it deprived Black citizens of their right to serve on a jury, which was independently important and protected under the Constitution. The voice of people, the right to participate in solving disputes. I mean, just pause for a second. I know I'm preaching to the choir here, but there is something quite beautiful about the American conviction that ordinary people putting their heads together, 12 of them at a time, can solve a dispute for two strangers in a way that is sensible and rational and will do justice between them. Right? We take the word of the jury about what happened because we trust them to make that decision. And by saying we trust them to make that decision, we are saying they are trustworthy as citizens. And that is a very powerful, uniquely American statement. No one is above the law, and no one is too far below it to administer justice. That's what the jury trial does. I really think I'm a huge believer in the jury.
Quentin, what's your experience been with jurors that you've had?
My experience consistently in literally every jury trial I've ever tried has been the jurors feeling that they participated in democracy, they participated in justice, that they did something that was bigger than them. They are there consistently exercising one of their foundational constitutional rights. And it's no coincidence that studies consistently show that although there's grousing about serving on juries, that, you'll get thousands and thousands of hits on Google if you ask how to get out of jury duty. However, once you serve, even once, your whole view of the process and of our government and of the system of justice and of our system of government is transformed every single time. And the idea that somehow jury trials, the inefficiencies of them, and yes, there are inefficiencies, the costs of them, yes, there are costs, merit shutting them down or curtailing them or dramatically limiting them, again, is an erroneous idea. We've had a precipitous drop in the number of cases that actually get to trial. By many statistics now, 1% to 2% of all filed lawsuits go to trial, criminal and civil, in federal and state court. So, the jurors and the jury system, they're a feature, not a bug. They are there for a very specific purpose, to be the voice and conscience of the community. And again, back to arbitration, arbitrators are not the voice and conscience of the community, nor can they be, nor should they be.
Yeah, it's sort of, it takes me back to something my grandma used to say, which is, don't let the perfect be the enemy of the good. And there's plenty to complain about in our system. The question is, what is a better system? And I think it's sort of interesting. It's taking me back to where we started, right? You read this article, Quentin, about the UK perhaps eliminating jury trials for reasons of efficiency and all the rest of it. And it made me think about when we talk about jurors, when I go in front of a judge, they always say, my top priority are the jurors. Top priority is the jurors. So I want this to be efficient for them. And I learned something really important many moons ago. One of my early civil trials was down in San Diego in front of a judge named Tim Taylor. And Judge Taylor had us voir dire 82 people at one time. Everybody sat in the order in which they get called up. He gave us essentially 2 days between us and the defense to voir dire the entire panel. And at the time, I was like, how do you voir dire 82 people at one time? And what at least my takeaway from that was we don't need more efficiency in jury selection. We don't need jury selection to be shorter. If anything, we need it to be longer. We need more of the jurors to participate. I think the jurors that understandably grouse about jury selection was they sat around for 2.5, 3 days, and they sat in the audience and never got asked a question. But when everybody is participating, when everybody can give their 2 cents about how they feel and how they think about things, and they feel like they're being heard, right? Isn't that kind of what we all want? I mean, certainly what we want in our intimate relationships, but I think it's also what we want in our friendships and our community relationships. And so I think sometimes we get it wrong that efficiency is not the end goal all the time. It's meaningfulness that I think maybe is the end goal. So if both of you have had this experience and I've had the same experience, I've never had a juror afterwards come up to me and say, what an incredible waste of my time. In fact, if anything, they want to talk for a long time about the case. So what does that tell us about the importance of a jury trial in today's world, in today's political world? Is it more important or less important, do you think, based on where we are politically?
I think more important. I think
okay.
more. And part of it is because I think it's one of the few areas, particularly post-COVID, one of the few areas where people still have to find a way to work with people that they might not choose to work with. Fewer people go to church, and those people that go to church tend to go to the churches that are filled with people like them. We don't have a lot of multicultural churches. We have a lot of consumer-driven churches. We don't bowl, maybe kids' soccer leagues and baseball leagues, but those are also often oriented by neighborhood. So you're with people that are like you. There are few places in American life today where you can encounter and have to work with people who are dramatically different than you, other than in jury service. And that is a pure good. It is a pure good because it's very easy to think less of people you don't know. But when you meet them and you see that they have the same gifts and the same worries and the same hopes and goals and dreams, and you work together to reach a result about what is the right result here, it changes how you think about your neighbors and about people who aren't your neighbors. And I think that is an affirmative social good.
And you ask about the importance today, Craig. It's no coincidence that one of the first acts of every authoritarian regime in history is to eliminate jury trials, whether we're talking the Nazis or the Bolsheviks or whomever, because jurors form an essential bulwark against arbitrary power. And remove jurors from the equation and you remove accountability. Remove jurors from the equation and the authoritarian government can do what it wants. Remove jurors from the equation and you have permanently and dramatically weakened that democracy that you inherited and came in as an authoritarian dictator. And so today, in an era where we have around the world the rise of authoritarianism in many countries, the idea that we have jurors in these United States who can sit and serve as an essential bulwark and a foundation of our democracy, I think we need to be very, very skeptical of any attempts, even from inside or outside, to eliminate jury trials and to curtail the power of citizen jurors, because some of those attempts are innocent based on misunderstandings, as I said earlier, but some of those attempts are deliberate, cynical attempts by corporations and others who want to avoid accountability for wrongdoing.
So we've talked about how these arbitration agreements are prolific. They're everywhere. They're in, seems like almost everything we do or interact with. What is it that you think, what is the role for trial lawyers or lawyers generally who have sworn a duty to uphold the Constitution and everything in it, which would include trials, jury trials? What do you think it is that lawyers should be doing to try and further that goal and fight against these arbitration agreements?
Well, by virtue of having attended law school and having obtained our law licenses, and making our livings in toiling in the vineyards, if you will, of the courthouses, we have specific and unique information that many in the public don't have. We have specific and unique obligations and duties. I think you could call them fiduciary duties without exaggeration. And I think we need to be speaking up about arbitration and assaults on the rule of law and matters that we have unique information about. We need to be speaking up with one unified, full-throated voice, saying that arbitrations need some limitations, that we're not trying, no one is trying to outlaw them, nor do I think it's realistic to think they would be outlawed. But the idea that innocent people with non-equal bargaining power are being forced into these mandatory secret proceedings is repugnant to most people, and we have unique knowledge of that as trial lawyers. Likewise, we have unique knowledge of the necessity for the rule of law to be preserved, for judges and trial lawyers to be able to do their jobs and to carry out their duties without threats and intimidation and retaliation simply because they're on the wrong side of the V of the government or a particular member, whether it's a president or anyone else of a government. And so we need to not simply sit silent. We need to be speaking up and speaking out with a full, unified, full-throated voice.
Kathy, your thoughts?
I agree with that. I think the role of lawyers in the system is to help make the system better. And so we need to do at least two things. We need to be sure the public is aware that while, as Quentin says, arbitration has its place, it does involve the waiver of important constitutional rights, and it is corrosive in important ways of public transparency and accountability and citizen democracy. And for those reasons, we should be talking, as we are today, about the risks and difficulties of arbitration. And we should do our part to make sure that when it is occurring, it is between equals, people with full information and equal bargaining power who are making free choices to do that. I think those are all duty to the system issues that we have as trial lawyers that we ought to be speaking about.
Are there, I'm sort of thinking as I'm hearing both of you talk about this, some very kind of practical ways in which lawyers themselves can make sure that they're not playing into this system, which is looking at their own contracts and making sure their own contracts don't have arbitration agreements in it, not advising clients that arbitration is actually a good idea, that it's actually a bad idea for all the reasons we've talked about. Seems to me there's almost a checklist you can make of things that lawyers themselves could do within their own, just kind of within their own universe to kind of further that ball forward. And maybe we'll do that. Maybe we can post that if we can put our heads together and think of some.
Well, the Texas Bar has a rule that does not allow you to mandate arbitration as part of an engagement letter, and requires that you advise clients before they enter into an arbitration agreement of both the risks and benefits and costs of arbitration. And so most lawyers I know who have arbitration provisions in their engagement agreements advise clients to get independent counsel to review them and include a pretty robust disclosure of both the risks and costs. And one of the two of the risks of arbitration about which you are required to advise people is the lack of appeal and the loss of your right to a jury trial. So the Texas Bar has done, I don't know if it's the Texas Bar, Quentin, or maybe it's the State Bar ethics opinion, but there's a very, very long Texas Bar ethics opinion that addresses what is and is not permissible in an arbitration agreement. And ironically, it meets many of the objections we've talked about. That is, you're dealing with a client before a dispute, but you're telling them about the benefits of it. You're giving them a choice. They're getting independent counsel. So it's possible to have the reality of arbitration be what the aspiration was, which is a freely bargained for choice about a better way to resolve disputes if that is suitable.
Look at that. Texas, giving us a little learning for all of us.
Yeah.
Maybe we should try and promulgate that throughout the states. And, I think there's one other issue I just want to make sure that people have clarity on. And I think that sometimes there's a perception about arbitration, that we've already talked about how they say it's more efficient. It isn't. It costs less. It doesn't. But I think sometimes I hear a complaint that, well, lawyers want to get rid of arbitration or not have arbitration so much because they make more money doing trials. Is that true? Is that your experience?
It's not my experience. My experience is that arbitration takes just as long, if not longer, because you have the intervention in many cases of arbitrators who, unlike judges, don't have busy dockets, don't have incentives to move matters along, and get paid by the hour to appear. And so my experience is not that arbitration is faster or cheaper.
That's been my experience as well.
But, I'm talking about big, Craig, it could be a function of people's practice. I mean, my practice is large commercial cases, and so it's almost never faster or cheaper to arbitrate.
Sure. But Quentin's doing more of the kind of David versus Goliath, and it sounds like you've had the same experience, right, David?
Sure. It's we end up having discovery. We end up having testimony under oath. We end up having, just as Kathy has described in her commercial cases, a little mini MI trial. Except we're paying a judge basically, who's not a judge. It's an arbitrator, but we're paying a judge-like person to preside over it, and the meter's running, and it's not, for all the reasons Kathy has articulated much better than I have. Arbitration is a failed. It doesn't accomplish generally what it was touted to accomplish. If people understand that, corporations understand that, they go into it with eyes wide open. Particularly in specialized cases, there's certainly a place for arbitration.
Right, and just so the public's clear, so the two of you have a different business model, right? Kathy, you're billing by the hour, I presume?
Not always. I work on contingent fee.
What's that?
I work on contingent fee, Craig.
Oh, most of your cases are contingency fee.
My plaintiff's commercial cases are almost all contingent fee.
Okay.
My defense commercial cases are by the hour. Often we have reverse contingencies, but yeah.
Gotcha. And then
Quentin, but the people against me are all working by the hour.
Right. And Quentin, you're all contingency?
All contingency fee, yes. Meaning I don't get paid unless and until my client does, and I front the expenses.
Right. So to the extent that you've got expenses to pay a judge, to pay a discovery referee, to pay all those folks that you might have to pay in arbitration, those aren't costs you're going to have, presumably, at least not in every trial. In most trials, you're never going to pay a judge. If you did, that's probably illegal. The costs are just being driven up, actually. So the attorneys are doing just fine. The costs to the client are more. So really, if we just look at from a purely monetary standpoint, lawyers, in terms of what they get paid, isn't changed dramatically between the two, except for in a contingency case, the plaintiffs are losing almost all the time, and so they're never getting paid, and the lawyers are never getting paid. But that's a function of the things we talked about earlier, which is the deck is stacked, right?
Well, and also the waiver. I mean, many arbitration agreements come with waivers of exemplary or punitive damages.
Yeah.
And so that has a big impact on the risk of the trial to the corporation and the reward of the trial to the injured person.
So if a corporation has acted with malice or with wanton disregard for life or safety, they can't be held responsible for that piece, only for negligence.
Yeah, there are public policy arguments that in the case of intentional actions, you cannot bargain around exemplary damages, but there are certainly efforts by legislators in some states in the guise of what is called tort reform, but is probably something else, to eliminate exemplary damages.
All right. So I just had an idea. I've got two great trial lawyers here. And every great trial lawyer knows you got to have a theme or a theory of your case. You got to have something that's easy to remember for the jury. So when they go back in that jury room, they're going to find for your client. So I'm going to put you both on the spot. If you had to give your very short theme or theory to average person on the street about why jury trials are important and they should care about them, I want to know what that would be. I want you to think about it for a minute. I'm going to give you a second because I'm putting you on the spot. But it has to be memorable. It has to be meaningful. It has to be something you think might actually move the needle for them.
I'll go.
Whenever you're
Kathy's the two most essential pillars of our democracy, in my view, are voting for the representatives who pass our laws and govern us, and serving on juries. And many of us don't fully appreciate the degree to which our founding fathers implicitly and explicitly represented and recognized the connection between jurors and our freedom, jurors and the legitimacy of our government. And so today, it is every bit as vital as it was in 1776 and 1789, the idea that citizen jurors are protecting our freedom, they're legitimizing our democracy, and they're giving all of us the opportunity to essentially be deputized for the length of the trial in self-governance, and it works. Jurors work. They get it right the vast majority of the times. Once in a while, you see something in a newspaper and you think, why do those jurors do that? Inevitably, had you sat through that trial, you would have done the same thing had you been on a jury and heard those facts. And so let's not throw out the baby with the bathwater. Let's not be seduced by the siren song of more efficiency, cutting costs, expediting this or expediting that. The jury system works. It has worked for hundreds and hundreds of years. We need it today more than ever.
Quite the closing.
It was. It was.
Kathy, what do you got?
I'm going to link it to something else I care about, which is voting rights. And I would say it very simply. They wouldn't try so hard to keep you from voting if your vote didn't matter. They wouldn't try so hard to keep you from serving on a jury if your voice on a jury didn't matter. Your voice matters. The Constitution guarantees you the right to speak in both contexts. You should be very suspicious and resist any invitation to have those rights be rendered meaningless. Because they aren't. They matter.
I think if I was going to pitch it to the average person, I would tell them, your only shot, there is no other way, the only shot to get justice against corporations, insurance companies, or billionaires is a jury trial. That's it. So if you don't care about having a shot against those people ever, go ahead and let go of it. But if you care about that, if you think that's important, you should fight like hell to keep it, because that's what our founders did.
Well said.
Amen.
I don't know if that would move the needle, but motivates me.
Yeah.
So great. Jury won. I won. All right. Well, listen, thanks everybody who joined us and listened to this. We really appreciate you listening to our podcast, The Rule of Law, The Academy Speaks. Kathy Patrick, Quentin Brogdon, thank you both so much for sharing your time, your incredible intellect, your knowledge about this issue, your experience that you've had, which I think brings so much to this issue. It's really been an interesting discussion. I'm sure that we will have more of these. For our listeners, please continue to listen to us wherever you get your podcasts or wherever you find podcasts. The Rule of Law, The Academy Speaks. Thanks very much.
Thanks.
Thanks.